Hello, this is Alexander Cross, Criminal Defense here in the San Francisco Bay Area. If you'd like to learn more about criminal defense, don't forget to subscribe to our channel, Law Offices of Cross & Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos for you. So, we received an interesting inquiry here on our YouTube channel. This has to do with somebody who got accused of hit and run while drunk. Let's see here. A friend of my son had an accident driving my vehicle. They fled from the scene. They did not realize that the car plates had fallen. The police came to my house to question and arrest me. Well, first of all, did you in fact get arrested, or did they just question you? Because usually for hit and run cases, they don't just flat out come and arrest you unless they have evidence that you were the one that was driving the car. Because just because you were the one who was the registered owner doesn't mean that you were the one driving the car. If there are witnesses who can attest to the fact that, no, a couple of young guys were driving the car and this guy's 55 years old, well then, no. Well then, they can't, it doesn't go that well. Just because you're the registered owner of the car doesn't mean that the DA will actually file charges against you, because they are very well aware. They're very well aware that many people get their cars stolen or lend their cars to kids or to the friends of their kids. These things happen all the time. All the time. So before deciding, oh, he's the registered owner of the car, they're going to file charges against me, well, no, not yet. They have to investigate the matter. Now, if you throw your son under the bus, now usually we tell people, don't talk to the police, don't say anything, because anything you say or do will be used against you in court. Obviously, you don't want to be giving details, but if you want to clean your hands, you say, hey, look, my son uses the car all the time. That's all I'm going to say. That may be enough. That may be enough to kind of sort of get the police off your back. Of course, they're going to be investigating your son and your son's friend, and that's going to be a decision that you have to make. But generally speaking, aside from saying a quick little thing like, hey, I lent the car to my son, or I lent the car to his friend. That would probably be just enough to get them off your back, but then you're going to have to deal with the drama of your son being charged with a crime or his friend being charged with a crime. That's something you're going to have to figure out for yourself. But generally speaking, I usually recommend just remain silent, because it's the police that has the obligation of reviewing and investigating the case, and it's the DA who has the obligation, they have the burden to convince a jury that you are guilty. Remember, they are the ones that have the burden of proof, not you. Let them do their investigation. Regardless, if you'd like to learn more about criminal defense here in the San Francisco Bay Area, don't forget to subscribe to our channel, Law Offices of Cross & Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos. But if you've been accused of a crime and need representation in court, call us now for a free consultation at 1-800-862-7677. Once again, 1-800-862-7677. Criminal lawyer, criminal lawyers. DUI lawyer, DUI lawyers. Criminal attorney, criminal attorneys. DUI attorney, DUI attorneys.